Welcome to Understanding the Structure of the Federal Court System. This is my Teach Back presentation that explains the structure of the federal court system and the process through which a case can travel from one court level to another. What are the roles in federal court system? The foundations of the federal judiciary are as follows. There are 94 judicial districts, including at least one in each state, plus territories like Puerto Rico and Guam. These courts make up the lowest level of the three-tier federal court system, which consists of district courts, also known as trial courts, circuit courts, which are the courts of appeals, and the U.S. Supreme Court. Then there is the original jurisdiction, which means that the district courts have original jurisdiction, meaning they are the first to hear and decide a case rather than reviewing decisions made by the lower court. The roles of the district courts. Before we dive into that, let's just dive into what exactly district courts are. They are the general trial courts of the federal court system in the United States, and they are the courts of first instance, meaning they are the starting point for most federal cases, both civil and criminal. How they are handled, how the cases are handled. They conduct trials, which include both jury trials and bench trials, and this is where the judge decides the case without a jury. Then they hear evidence. So the district courts take witness testimony, consider physical and documentary evidence, and they hear arguments from lawyers. They also apply a lot of facts. The judges and sometimes juries decide the outcome by applying federal law to the facts presented. And the types of cases handled are as follows. Federal criminal prosecutions, so for example, drug trafficking, fraud, terrorism. Civil lawsuits under federal law, again, for example, civil rights violations, federal tax disputes. Civil cases involving diversity of citizenships, which are parties from different states with more than $75,000 in dispute, and habeas corpus petitions, which are challenges to imprisonment. And the importance of district courts, they're important because they handle the majority of the federal judicial workload, and they create the trial record that may be reviewed on appeal. And they also ensure that federal laws are enforced and interpreted at the ground level. The function of the appellate courts. So the U.S. Courts of Appeals are also known as circuit courts, are the intermediate level of the federal judiciary, and they sit between the district courts, again also known as the trial level, and the Supreme Court. And their main function is to review decisions made by district courts and determine whether the law was applied correctly. So their function is to review lower court decisions. The Court of Appeals do not conduct trials or hear new evidence. They review the legal proceedings and decisions of district courts to ensure that proper legal procedures were followed and that the law was interpreted correctly. There are panels of judges rather than just one. Cases are usually decided by a panel of 3 judges, though occasionally en banc, which means full court. Hearings are held for particularly significant cases. And then they focus on legal issues. And so the appellate court looks at questions of law, not questions of fact. So, for example, it might decide whether the district court properly instructed the jury or correctly interpreted a statute or constitutional principle. So, appellate jurisdiction is the authority of a court to review, amend, or overturn decisions made by lower courts. The U.S. Court of Appeals have appellate jurisdiction over cases from federal district courts, certain federal administrative agencies, some specialized courts like bankruptcy courts. Appellate courts do not hear new evidence or retry cases, which I previously stated. Instead, they review the trial record, consider written briefs and oral arguments, and they issue opinions that they may affirm, reverse, or remand the case. Some outcomes. So actually, the outcomes of an appeal are affirm, reverse, or remand. And an affirm is when the appellate court agrees with the lower court's decision. The reverse is when the appellate court disagrees and overturns the lower court's ruling. And the remand is the case is sent back to the district court for further action. So, for example, new trial. And I actually have experience with this currently with a family member as we pushed for a motion for remand, which was denied. So we are currently going through the appellate process. The importance of the appellate courts, they help ensure consistency and fairness in how laws are applied. They shape legal precedent, especially since the U.S. Supreme Court hears only a small number of cases each year. Most federal appeals end at this level, making these courts highly influential. The role of the Supreme Court, they are the highest court in the nation. They sit at the top of the judicial branch and has the final authority in interpreting the U.S. Constitution and federal law. Its decisions are binding on all lower federal and state courts. And then there is the judicial review, which was established by Marbury versus Madison in 1803. The court has the power to declare laws or executive actions unconstitutional. This ensures that the legislative and executive branches act within constitutional limits. And then resolving conflicts. The court resolves disputes involving federal law, constitutional issues, and conflicts between different states or between state and federal law. And then precedent setting. The court's rulings set legal precedents, stare decisis, shaping the interpretation of laws for generations. How cases actually reach the Supreme Court. There is the writ of certiorari. Oh my goodness, I wish I knew how to say this word. Certiorari. Oh my gosh. Certiorari. Most common route. Parties who lose in a lower court can petition the Supreme Court to review their case by filing a petition for writ of certiorari. I wish I could say this. I don't know why I have such a hard time saying this word, but this is so complicated for me. The court receives thousands of petitions each year, but grants only about 1%, which is about 70 to 80 cases. The rule of four, at least 4 justices must agree to hear a case. Then there is the appeals from federal and state courts. Federal courts of appeals, most cases come from the 13 U.S. courts of appeals. State Supreme Courts cases can come from state courts if they involve a federal question. For example, constitutional rights or federal law. Then there is the original jurisdiction, which is a very rare case. The Constitution, Article 3, Section 2, gives the court original jurisdiction in a small category of cases such as disputes between 2 or more states, cases involving ambassadors or foreign officials. And then these cases start directly in the Supreme Court rather than being appealed. And again, that's a very rare situation. And then certification. A lower appellate court may ask the Supreme Court for clarification on a legal question by certifying the issue. The Supreme Court may choose to answer, but it rarely uses this path today. And then digging really deep into the process, and I've already kind of touched a little bit upon it, so I won't really dig too deep. But the process is to go through the district court first, which again is that trial court level, and this is again the starting point. The process is that the evidence is presented, witnesses testify, and the judge, sometimes the jury, makes a ruling. The outcome determines whether the plaintiff, which is the one who brought the case, or the defendant, the one who is being sued or prosecuted, prevails. The appeal option, the losing party can appeal to a higher court if they believe there was a legal error. And then step 2 would be the Court of Appeals, which is the intermediate appellate level. And again, they have 13 courts of appeals, which is again the circuit court. Their role is to review whether the district court applied the law correctly. And again, they do not retry the case or hear new evidence. They simply just read the facts and look for any errors. The key elements in the appeals process is notice of appeal, the briefs, so the written arguments submitted by both sides, so the appellant and the appellee. And then the decision usually comes from a panel of 3 judges, which may affirm, reverse, or remand. And again, we already touched on that. And then it goes to the U.S. Supreme Court, which is the final level. And then there is a discretionary review, which means that the losing party at the appellate level can petition the Supreme Court to review the case through a writ of certiorari. Certiorari, I think I got it down this time. And then there's a selection out of thousands of petitions. Only about 780 cases are heard, which again was that 1%. And at least 4 justices must agree to take the case, which was again that rule of 4. So a lot of repetition here, but it's important to understand the process. And then they also have the briefs, which both sides submit with detailed arguments. Then there is the amicus curiae, which is the front of the court briefs, which could be filed outside by outside groups with an interest in the case. And oral arguments, they usually last about 30 minutes. So each side's lawyer presents those, and then they can answer questions from the justices. Conference and voting, the 9 justices meet privately, they discuss the case, and they vote. And then opinion writing, majority opinion explains the court's rulings and sets precedent. Concurring opinions may agree with the result, but for different reasons, and dissenting opinions explain why some judges disagree. And then just to go over the role of the plaintiff and the defendant in the appeals process. So the plaintiff for prosecution in the criminal case, they may appeal if they lost in district court. Though in criminal law, the government generally cannot appeal a not guilty verdict due to double jeopardy. And then the defendant may appeal a conviction or unfavorable ruling arguing legal errors were made. And then in appeals, they become the appellant and the appellee instead of the defendant. And I can't think of the word. And the prosecutor. Okay. Sorry, I lost my train of thought there for a second. And then to kind of sum things up, I chose to research the Miranda versus Arizona case in 1966. So just to give a little bit of background on this case, Ernesto Miranda was arrested in Phoenix, Arizona for kidnapping and assault. After 2 hours of police interrogation, he confessed. At the trial, prosecutors used his confession as evidence. Miranda's lawyers argued that it should not count because he wasn't told he had the right to remain silent or to have an attorney. So that's where the term was coined, Miranda rights. But the path through the courts, so what happened for this court case, um, it started through the district court, which was the trial court, but actually it started in the state court since Miranda was arrested under Arizona law. He was convicted based on his confession and sentenced to prison. So, although typically you would start in your district court, trial court, he actually went to a state court instead. And then step two, state Supreme Court, which was a path to the federal courts. Miranda's lawyers appealed to the Arizona Supreme Court. The court upheld his conviction, saying his confession was invalid even without a warning of rights. His lawyers then appealed it to the U.S. Supreme Court. And apparently, you can skip the federal appeals courts if you go directly from a state's highest court when it's a constitutional issue. And then step three, the U.S. Supreme Court. So the U.S. Supreme Court agreed to hear Miranda versus Arizona in a 5-4 decision on 1966. The court ruled that that suspects must be informed of their rights before questioning. These became known as your Miranda rights. So those are as read. You have the right to remain silent. You have the right to an attorney, and the court overturned Miranda's conviction. So, in summary, the trial court, which happened in Arizona, was actually a state court. He was convicted based on confession. The Arizona Supreme Court upheld the conviction, and the U.S. Supreme Court reversed it, creating the rule that police must tell suspects their rights, which became the Miranda rights. And my citations are my Miranda versus Arizona and my U.S. courts.